The following video is an analysis of the evidence presented at the Sauble Beach boundary dispute trial, heard in Toronto, Ontario, in late 2021 and early 2022. Evidence that is specifically relevant to the survey of the Saugeen Reserve boundaries is compared and analyzed against the research of David Dobson. Mr. Dobson was named in this action by Saugeen First Nation in 1995. He is the owner of the Crowd Inn restaurant in Sauble Beach, one of the properties in question that relates to the boundary dispute. Mr. Dobson has been actively researching this boundary dispute since 2008. Most of what he has uncovered has never been openly discussed during any pretrial meetings, nor was it presented and heard at the trial. Due to financial constraints, Mr. Dobson could not afford the legal costs and expert verification expenses necessary to present this information in court. Every level of government represented at trial, as well as Saugeen First Nation, are aware of Mr. Dobson's research. None of his many discoveries and analysis have ever been successfully disputed, nor proven to be incorrect.
When Saugeen First Nations Reserve was being defined in 1854, a mistake was made. Because of a geographical misunderstanding regarding the direction of Cway Road, the negotiated agreement was not adhered to, as intended. The original treaty instructions described the western boundary incorrectly. In 1855, Saugeen First Nation asked for this error to be corrected. As a result, there was an amendment made to the first instruction from the original treaty text. After the amendment, the disputed beach, the area under contention today, from Lot 2526 to midpoint Lot 31, was officially no longer part of the Saugeen Reserve. The following are the incorrectly defined boundaries of the Saugeen Reserve, according to the original treaty instructions. All that block of land, bounded on the west by a straight line running due north from the river Saugeen, at the spot where it is entered by a ravine, immediately to the west of the village, and over which a bridge has recently been constructed, to the shore of Lake Huron. On the south, by the aforesaid northern limit of the lately surrendered strip. On the east, by a line drawn from a spot upon the coast, at a distance of about 9 miles and a half, from the western boundary aforesaid, and running parallel thereto, until it touches the aforementioned northern limit of the recently surrendered strip. When Saugeen First Nation became aware of the mistake to their boundary, the Cway Road Amendment was negotiated and then implemented. The following are the Cway Road Amendment instructions. First, that the reserve, known as the Saugeen Reserve, now bounded on the west by a straight line running due north from the river Saugeen, at the spot where it is entered by a ravine, immediately to the west of the village, be bounded instead by the Indian path called the Cway Road, which takes a northwesterly direction, as shown by the red line in the plan. This change will give the Saugeen Indians a small increase of frontage on Lake Huron. This amended description of the western boundary, by the Indian path called Cway Road, which takes a northwesterly direction, was merged with the original treaty instructions. It was inserted right after the phrase, all that block of land, bounded on the west. The phrase, to the shore of Lake Huron, from the original treaty instructions, is then moved directly behind the inserted content from the Cway Road instruction. The phrase is moved because as a result of the amendment, the western boundary termination point at Lake Huron is where Cway Road and Lake Huron meet, not where the due north straight line from the Saugeen River terminates at Lake Huron. This description is what is illustrated on Rankin's final map. The change to the first treaty instruction affects all the treaty terms. As a result, the starting point for the 9.5-mile shoreline measurement does not begin from where the original western boundary terminates at Lake Huron, it begins from where Cway Road terminates at Lake Huron. The instruction from the treaty, relating to the shoreline boundary states. On the east, by a line drawn from a spot upon the coast, at a distance of about 9 miles and a half, from the western boundary aforesaid. As a result of the amendment, the western boundary is now Cway Road. In order to follow the treaty instructions correctly, Cway Road is where the 9.5-mile measurement must begin. This is perhaps the most significant piece of information to understand when discussing the Saugeen Reserve boundary dispute. The Cway Road Amendment did not only change the Saugeen Reserve's western boundary location, it also changed the location of the northeast termination point from midpoint Lot 31 to Lot 2526 Main Street. A distance of 1.4 miles. A subtraction to the shoreline that is the same distance to what was gained from the north point of the original western boundary to Cway Road. It is almost exactly 9.5 miles from Cway Road to Lot 2526 Main Street, the same distance as stated in the treaty terms, the same distance as it is from the original western boundary to midpoint Lot 31. The corrected text then becomes: all that block of land, bounded on the west by the Indian Path, called the Cway Road, which takes a northwesterly direction to the shore of Lake Huron, from a straight line, running due north, from the river Saugeen, at the spot where it is entered by a ravine, immediately to the west of the village, and over which a bridge has recently been constructed. The remaining treaty instructions then follow the first, corrected, treaty instruction, the same way they were originally written. On the south, by the aforesaid northern limit of the lately surrendered strip. On the east, by a line drawn from a spot upon the coast, at a distance of about 9 miles and a half, from the western boundary aforesaid, and running parallel thereto, until it touches the aforementioned northern limit of the recently surrendered strip. Could this be any clearer? These amended treaty instructions are the correct treaty instructions, the way the treaty was intended to be written. Relocating the western boundary to Cway Road? This is the actual boundary dispute. It is not the illogical and convoluted submissions by SFN and Canada from today. Their conjecture and assumptions don't conclusively resolve anything. The boundary dispute was resolved over 160 years ago. The boundary dispute, as I have described it, took a little less than 6 minutes to do so. It is the correct representation of the historical documents. It is straightforward, and it leaves no ambiguities. Granted, those of you who are new to this information may find it a little overwhelming to digest on your first take. Although, I am confident, with a small amount of Q&A, along with familiarizing yourself with some of the locations and treaty terminology, what I have presented would satisfy any wariness you may have. For those of you who are familiar with the evidence and have no personal bias, I am sure what I have presented is crystal clear. The historical evidence is straightforward, it is not ambiguous. There was a negotiation. There was a mistake made as to the location of the western boundary. The mistake was asked to be corrected by Saugeen First Nation. There was an amendment to the treaty instructions that corrected the mistake. The correction altered the treaty wording, while still observing the original treaty terms. As a result, the entire 9.5-mile measurement was shifted 1.4 miles to the south, bounding the west boundary to Lake Huron, at Cway Road to the south, and terminating the Saugeen Reserve at Lot 2526 to the north. The Cway Road Amendment instructions that I have described are a perfect match to the Saugeen Reserve boundaries illustrated on Charles Rankin's final map. They are the only instructions that can be used that will match Rankin's final map. The original intentions of both negotiating parties, Canada and Saugeen First Nation, regarding the boundaries of the Saugeen Reserve, were satisfied in 1855. There is nothing further to discuss with this interpretation. It is in agreement with all textual and illustrated evidence related to the original and amended treaty instructions. It is also in agreement with all surrounding evidence that directly relates to the boundary dispute. Most importantly, it is the only interpretation that matches the treaty terms to Rankin's final map. Crystal clear is something that cannot be said of the presentations of Saugeen First Nation and Canada. I would like to untangle the ambiguities of their presentations and give clarity to why their information is false. Unfortunately, this will take a lot longer than 6 minutes. This presentation should not be thought of as provocative material. It has been researched and justified as well as any other. Based on the nature of the content, however, it is unlikely to be overly entertaining. I have done my best to make it stimulating, and it should be critiqued based on the entirety of its content. If you are closely tied to the geography affected by this trial, Sauble Beach and the Saugeen Peninsula, or if you would just like some hard facts that offer an opposing view to the submissions of SFN and Canada, I think you will find this presentation very interesting. I encourage you to observe and consider everything that is presented. After watching the trial for Saugeen First Nation's claim to Sauble Beach, you may be impressed by the sheer volume of documents, studies, history, and general information presented over the 6-week period. As interesting as these presentations may have been, the majority of the information was unnecessary to help resolve a simple boundary dispute, which has become convoluted through misinterpretation and time. Perhaps some of these presentations give some context to what was happening in that time period, but most of it did nothing to resolve the correct boundary locations of the Saugeen Reserve. This is a boundary dispute, and the primary focus should be the negotiations regarding the Saugeen First Nation Reserve leading up to the signing of the treaty, Charles Rankin's survey, and the events surrounding the survey that influenced Rankin's decisions. The Treaty 72 document, and the amendment to that document, sometimes referred to as the Cway Road Memorandum, or Amendment. These listed items relate most significantly to the investigation, and what is most relevant to solving how the Saugeen Reserve boundaries were created. Other information presented helped illuminate less significant details, but let's not lose sight of what is at task by overcomplicating things. Wading through dense reports that hold little significance. The task? To prove whether Saugeen First Nation received the intended boundaries of their reserve, but more specifically, the boundaries they believed they had negotiated in 1854. In this presentation, I want to show why Saugeen First Nation and Canada have failed in this task. Point out what is wrong with their argument, and pinpoint exactly where they have made mistakes. The court says we must find the true intention of the 1854 negotiating parties to establish the correct boundaries of the Saugeen Reserve. The two negotiating parties in 1854 were Saugeen First Nation and the Crown. Today, these same two negotiating parties have united to say, you only need to look at the treaty, as it was written on October 13, 1854, to find the true intention for the boundary outline of the Saugeen Reserve. However, the court also says, to find the true intentions of the negotiating parties, we must look to the surrounding events of the treaty. This is where Saugeen First Nation and Canada have taken liberties with the facts to support their narrative of how the surrounding events played out. They have totally disregarded some events and misinterpreted other information. First, Saugeen First Nation and Canada have misinterpreted a directive from the Superintendent of Indian Affairs, Lord Barry, when he was instructing Charles Rankin on how to proceed with the Cway Road Amendment. As a result of this first misinterpretation, Saugeen First Nation and Canada are using the wrong treaty instructions to support their position that the Saugeen Reserve shoreline boundary should terminate at midpoint Lot 31. They use the original treaty wording rather than the amended treaty wording. This mistake has gone unnoticed and therefore was never acknowledged in the courtroom. Second, they have misinterpreted a statement from the Cway Road Amendment. The Cway Road Amendment states that Saugeen First Nation would receive an increase in frontage on Lake Huron as a result of the change to their western boundary. SFN and Canada have interpreted this to mean that the amendment is a standalone agreement, separate from the original treaty instructions. Third, they have totally disregarded the original intentions of both negotiating parties, Saugeen First Nation and the Crown. It is documented that the western boundary of the Saugeen Reserve was to be laid out according to an agreement made between Lawrence Oliphant and the Saugeen Band, negotiated before the signing of the treaty. The notation at midpoint Lot 31 is the most predominant piece of evidence Saugeen First Nation and Canada rely on to support their investigation. Without examining the Cway Road Amendment evidence thoroughly, one could be misled to believe that Saugeen First Nation and Canada's research is correct. Everyone, experts included, have blindly accepted their assertion the original treaty instructions are to be followed. This is because the Northeast Angle Indian Reserve notation at midpoint Lot 31 on Charles Rankin's draft map has confused some of the issues relating to the surrender. They believe that this notation ultimately identifies the northeast corner of the Saugeen Reserve as described by the original wording of the treaty. It is true. It actually does identify what was mistakenly thought to be the northeast termination point of the reserve. This is where you need to carefully analyze the surrounding events. Charles Rankin traversed the shoreline in October 1854. At this point in time, he was under the impression that the instructions from the treaty, as written on October 13, 1854, were the instructions he was to follow. When Rankin traversed the shoreline of Lake Huron, from the Saugeen River to the Sauble River, and beyond, he marked many stations in terms of distance as he went. Two of these locations were the northern limit of the original western boundary at Station 16, and midpoint Lot 31, at Station 60. His measurements between these two locations marked the 9.5-mile treaty distance, and he, most likely, recorded the notation on the draft map at this point in time. October 1854. This was 11 months before the treaty was officially amended, and 7 months before Rankin would come to understand the true intentions of the negotiating parties. Therefore, it is irrelevant that he made the Northeast Angle Indian Reserve notation at midpoint Lot 31. The Cway Road Amendment ultimately relocated the northeast termination point to Lot 2526 in 1855. Another argument Saugeen First Nation and Canada put forth is that Rankin surveyed the eastern boundary of the Saugeen Reserve, starting from midpoint Lot 31, which, to them, proves that the original wording was used to locate the northeast termination point of the reserve. The location was used, but not to mark the northeast termination point of the reserve. It was used to determine a starting point to initiate the survey of the eastern boundary. The eastern boundary could not be contained on dry land, from midpoint Lot 31 to Lot 2526, so it is nonsensical to suggest that Rankin considered this portion of the survey as part of the Saugeen Reserve's eastern boundary. Although we can only speculate why Rankin would use midpoint Lot 31 as a starting point to establish the northeastern boundary of the reserve, when the treaty instructions suggest he should start at Cway Road. There is a very logical reason why he would do so. The 9.5-mile traverse from Cway Road to Lot 2526 was not plotted out by Rankin in October 1854. There had not yet been a complaint from the Saugeen Band that the original plotting was incorrect, so there was no reason for Rankin to think he should do this work. Instead, he plotted out the 9.5-mile course, from the original western boundary to midpoint Lot 31, as the original treaty instructions required. With this in mind, when Rankin was ready to survey the eastern boundary, in September 1855, he already knew the midpoint Lot 31 location. He knew where it was, from his traverse of the shoreline in October 1854. The work had been completed, it had been plotted out from Station 16 to Station 60. Because the shoreline has a concave shape, from Lot 31, running south, Rankin also knows that if he runs the eastern boundary line due south, through the water of Lake Huron, from the midpoint Lot 31 location, it will intersect with the shoreline once again to the south. The intersection point marks the northernmost point. The eastern boundary can be contained within a block of land. He also knows this northern point is about 9.5 miles from Cway Road. He knows this information from the distances between two other stations he marked on his shoreline traverse, Station 10 and Station 58. According to Rankin's measurements, the distance between Station 10, which is slightly north of Cway Road, and Station 58, which is slightly south of Lot 2526, is 9.12 miles. Once the unknown distances are added, it brings the total distance very close to 9.5 miles. However, as shown from the illustration of the Saugeen Reserve, on the Gray Bruce map, it is evident that Rankin knew he was going to make Lot 2526, the northeast termination point of the reserve, as early as January 1855. By the date of the Gray Bruce map, we are also left to conclude that Rankin knew the eastern boundary could not be contained within a block of land north of Lot 2526 when he made his traverse of the shoreline. The Gray Bruce map was completed only 3 months after he made his traverse. From this evidence, we can conclude that even before surveying the eastern boundary, Rankin was intending to make the shoreline boundary 8.1 miles, not 9.5. This was the only option open to Rankin at that time, since the treaty required that the boundaries were to be contained within a block of land, and that the shoreline measurement was to begin from the original western boundary. By these two treaty restrictions, 8.1 miles was all that was possible for Rankin, at least until the Cway Road Amendment was implemented. So, after the Cway Road Amendment was implemented, the most efficient way, using the information he has recorded, for Rankin to find the northeast location of the Saugeen Reserve, that can be contained within a block of land, and satisfies the directive of the Cway Road Amendment, is to start from midpoint Lot 31, not Cway Road. All he needed to do was follow the shoreline, due south, for 1.4 miles, from the northern midpoint Lot 31 shoreline location, and then find the southern shoreline intersection point, which is a little south of Lot 2526. Rankin's alternative was to traverse the shoreline, from Cway Road, for 9.5 miles, in order to determine where the amended, northeast termination point of the reserve is. A task, described by Saugeen First Nations expert witness at trial, as an arduous undertaking. Rankin most likely did not want to traverse the shoreline a second time, when it was not necessary. So, Rankin can find the amended northeast corner of the reserve, either by retracing a 9.5-mile distance, from Cway Road, through a grueling course along the shoreline, or he can locate it along the flat, sandy shoreline, at a distance of 1.4 miles, from midpoint Lot 31. SFN and Canada have not even considered this as a possibility, even though it establishes Lot 2526 as the northeast termination point of the reserve, the same location he marks it to be, on all of his maps. After listening to Saugeen First Nation and Canada's argument at trial, it is clear where they have made two major mistakes, and where they have simply ignored other information. it is clear that the deductions they have come to don't align with the facts, and it is clear that they have created a new narrative to fit with their own conclusions. A narrative that can sway you, if you don't pay attention to all of the relevant facts, from before and after the signing of the treaty. Their misinterpretations and selective adherence to the facts have led SFN and Canada on a wild flight of fancy. All Charles Rankin's maps that relate to the survey mark the northern termination point of the Saugeen Reserve at Lot 2526. This being so, how does SFN and Canada automatically conclude that the eastern boundary is the problem? The eastern boundary does not determine the northeast termination point of the Saugeen Reserve. According to the treaty text, it is the 9.5-mile shoreline boundary that determines the northeast termination point. How can SFN and Canada completely ignore the evidence of the Cway Road Amendment and conclude the eastern boundary was surveyed incorrectly? It was SFN that planted the seed of an incorrect eastern boundary survey. Since the 1890s, almost 40 years after Rankin completed the survey of the reserve, they began making this complaint. This is interesting, because it wasn't until sometime in the 1960s that midpoint Lot 31 was brought into play as the northeast termination point. We can only assume that SFN came to this conclusion based on the original treaty instructions, using a 9.5-mile shoreline measurement. However, prior to this, SFN argued that the eastern boundary should terminate at the Sauble River. And how did they come to this conclusion? I have to speculate on this somewhat, based on a statement made by Chief Lester Anaquat. In a 2019 Owen Sound Sun-Times article, Lester Anaquat was quoted as saying, according to Treaty 72, the specific land title is 9.5 miles north from Highway 21, which ends at 6th Street North, 2.4 kilometers north of the currently recognized boundary at Main Street by the Welcome to Sauble Beach sign. There is only one way to interpret this statement. Chief Anaquat is saying that the 9.5-mile measurement begins from Highway 21, where the eastern boundary terminates, at its most southern point. From that specific Highway 21 location, it is 9 miles to midpoint Lot 31, where it meets the Lake Huron shoreline. It is 10 miles to the Sauble River. Both measurements are very close to the term of 9.5 miles. An exact 9.5-mile measurement terminates at approximately 11th Street, and it is 7.5 miles to Lot 2526 Main Street. Based on this information, we can surmise that when SFN began making complaints in the 1890s, they examined the original treaty text, and upon review, misinterpreted where the 9.5-mile measurement was to begin. They concluded that the 9.5-mile treaty description defines the eastern boundary, not the shoreline boundary. An easy mistake to make if you read the confusing wording of the original treaty instructions. However, at the time of the trial, Lester Anaquat was the Saugeen First Nation chief. By 2019, through discussions with his legal team, he should have a firm grasp of the location they will be arguing at trial, of where the 9.5-mile measurement begins, according to the original treaty text. Chief Anaquat's description of the 9.5-mile measurement, from the news article, explains why the Saugeen Band made complaints about the eastern boundary in the 1890s. Speculation? Maybe, but there is no other way to interpret Anaquat's description and not see that there is a connection to SFN's complaint from the 1890s. It explains why SFN have been so focused on the eastern boundary for so long. Why is this significant? Because it explains how the notion that the eastern boundary was surveyed incorrectly got started. It shows that during their investigation, Canada took their eyes off the ball. While the shoreline distance from the original western boundary to midpoint Lot 31 was correctly accepted to be 9.5 miles, Canada incorrectly accepted a past complaint of SFN that the eastern boundary was surveyed incorrectly. Did SFN come to their conclusions in the 1960s, based on a 9.5-mile eastern boundary measurement, or a 9.5-mile shoreline measurement? Since the 1890s, has Canada ever asked? According to Chief Anaquat's description, SFN's conclusions have been based on a 9.5-mile eastern boundary measurement. Canada's focus should never have been the eastern boundary. It should have always been the 9.5-mile shoreline measurement and the Cway Road Amendment. If it had, they may have discovered that it is also 9.5 miles from Cway Road to Lot 2526. Perhaps then, their investigation would have been pulled in a different direction. As a defendant, Canada's investigation should not have been influenced by SFN. Let's be honest, are we to believe it is a magical coincidence that the measurement from Cway Road to Lot 2526 is almost exactly the same as the measurement from the original west boundary to midpoint Lot 31? And, in relation to the first magical coincidence, it is equally coincidental that Rankin mistakenly marks Lot 2526 as the northeast terminus of the Saugeen Reserve on all of his maps, but most importantly, his final and official map. If there are degrees of coincidence, this is in the red zone on the scale. SFN's expert testified that he was not particularly familiar with the Cway Road Amendment in terms of specifics. I found this to be shocking, considering Cway Road to Lot 2526 equals 9.5 miles, and Lawrence Oliphant and Saugeen First Nation originally negotiated Cway Road as where the western boundary would be bound to Lake Huron. To establish how important the Cway Road Amendment evidence is to determine the northeast corner of the Saugeen Reserve, these are the most relevant facts that must be considered. 1. Saugeen First Nation complained to Charles Rankin that George Gould, Rankin's assistant, was surveying the western boundary in the wrong location, according to what they believed they had negotiated. They complained that the original treaty instructions were written incorrectly. They were so upset by where Gould was positioning the western boundary, that they threatened physical harm and to break his surveying instruments. 2. Rankin reports SFN's complaint to Lord Barry, and advises him that the Cway territory requested by SFN can be surveyed, without the need of surrendering it to SFN, or altering the treaty terms, in any way. 3. Lord Barry then gets approval from the Governor-General, and grants Saugeen First Nation the requested change to the western boundary. Barry conveys to Rankin that on the order of the Governor-General, he is to carry out the survey of the Cway plot, in strict accordance with the terms of the surrender. 4. The amendment to the treaty is written, and it states, as a result of the change to the western boundary, the Saugeen Band will receive an increase in frontage on Lake Huron. It is these four events, regarding the Cway Road Amendment, that have led to two major misinterpretations of the evidence, by both SFN and Canada. Misinterpretations that have allowed an unwarranted, 32-year dispute, and counting. Canada actually gives recognition to a statement directed to Charles Rankin by Lord Barry.
By this time, Rankin was aware of the west boundary dispute, advising the Superintendent General of Indian Affairs, Lord Barry, on May 9, that the Saugeen desired to have an alteration made in the western boundary of the reserve, so as to make their old path, the Cway Road, the northwestern limit of the reserve, instead of the northwestern terminus, as set out in the treaty text. Barry replied that Rankin was instructed by the Governor-General to carry out the survey of this plot, in strict accordance with the terms of the surrender.
This statement contradicts Canada's position. They have misinterpreted what Lord Barry's statement means. When Lord Barry ordered Charles Rankin to survey the Cway territory, in strict accordance with the terms of the surrender, he did not mean, first, survey the boundaries of the Saugeen Reserve, using the original treaty instructions, and then survey the Cway territory second. This makes absolutely no sense. In order to carry out the survey of the Cway plot, Rankin needed to use the original treaty instructions, combined with the amendments directive, to be in compliance with Lord Barry's command. Instead, what Lord Barry meant was this: that the concepts of the treaty were to be followed, as originally negotiated, and the Cway territory was to be part of those same treaty concepts. This means the 9.5-mile shoreline distance is to remain 9.5 miles, and is to begin from where the western boundary is bound to Lake Huron. So, when Lord Barry says, terms of the surrender, he is saying, not just the first instruction of the treaty is affected by the amendment. All terms are affected by the Cway Road Amendment. Throughout the many investigations of this boundary dispute, since the 1890s, to recent years, nobody's investigation has ever matched the treaty terms to Charles Rankin's final map. Why? Because they have all used the original treaty instructions exclusively. Canada argues that it is a question of treaty interpretation, that the language of the treaty, the intentions of the negotiating parties, the surrounding events, and common sense, add up to one interpretation, that the treaty placed the northeast corner of the reserve, at a spot upon the coast, approximately 9.5 miles along the shoreline, from the westerly limit, as set out in the October 1854 treaty. Therefore, the reserve has to include the disputed beach, from Lot 25-26, to midpoint Lot 31. They say, any other interpretation defies logic, distorts the meaning of the treaty, and is inconsistent with the honor of the Crown. This is a fairly bold argument, since they admittedly don't know the specifics of the Cway Road Amendment. Without acknowledging and stating their position in regard to the alteration of the treaty, as a result of the Cway Road Amendment, their position is no more than a manipulation of the facts. There is no meaning to the treaty without the Cway Road Amendment. It is impossible for any of the evidence to make sense without it. Why? Because it is a part of the treaty, it is a correction to the treaty text, it defines what was originally intended by both Saugeen First Nation and the Crown. The directive of the Cway Road Amendment does not distort the meaning of the treaty, it brings into focus the true intention of the negotiating parties. What defies logic is that Canada refuses to recognize this. For many years, my own research was also guided by the influence of SFN and Canada's misconception that the treaty wording was to be followed word for word, a theory that I came to realize could never be proven. A theory that does not provide any clear answers. A theory which only creates more questions than answers. Questions such as: 1. Since the Superintendent of Indian Affairs, Lawrence Oliphant, and Saugeen First Nation agreed during negotiations that Cway Road would bound the western boundary to Lake Huron, how can it be the intention of both the Crown and Saugeen First Nation in 1854 that the 9.5-mile measurement should instead begin from the western boundary that is described in the original treaty instructions? How is Oliphant and SFN's original negotiation not being recognized today as the real boundary intention of the negotiating parties? How can SFN and Canada apply a different intention to the negotiating parties because of a mistake made during the negotiation process? How can a fabricated intention continue to be recognized and defended as the true intention solely on the grounds of the original text of the treaty? The negotiating parties rectified the geographical mistake made over 160 years ago through the Cway Road Amendment in 1855. If the western boundary was relocated, why wouldn't it stand to reason that the northeast boundary would be relocated as well? The western boundary, where it is bound to Lake Huron, and the northeast corner, are what define the 9.5-mile shoreline distance. One's the starting point, one's the termination point. How do SFN and Canada not see the connection between Lawrence Oliphant's original negotiation and the Cway Road Amendment? 2. It is historically recorded that in 1855, Saugeen First Nation complained that the original treaty wording was incorrect, according to what they believed they negotiated. How can SFN and Canada ignore this information and insist that the original treaty instructions are to be used? This simply does not make sense. It is only through manipulating facts and disregarding the purpose of the Cway Road Amendment that you can even make a case for using the original treaty instructions. Their theory cannot be proven because it isn't true. 3. If midpoint Lot 31 is the intended northeast termination point of the Saugeen Reserve, why did Charles Rankin, a seasoned professional, terminate the northeast point of the reserve at Lot 2526 on all of his maps? How could he have made this mistake when, on his October 1854 traverse of the shoreline, it is obvious he plotted out the 9.5-mile measurement? He used the original treaty text to establish the northernmost point of the original western boundary at Lake Huron, from a due north line, from the Saugeen River. During his traverse, he identified the location as Station 16. 9.5 miles from that point, he marked midpoint Lot 31, at Station 60. This proves that he understood his instructions, and he knew how to find the northeast termination point of the Saugeen Reserve. Then, 1 year later, he observes midpoint Lot 31 again, as his starting point for the actual survey of the eastern boundary. We are talking about two separate instances, where Rankin physically observes midpoint Lot 31 during his work in the field, yet he still marks the northeast termination point of the Saugeen Reserve at Lot 2526 Main Street on every map. How could this be possible? If his instructions are clear that he is to use the original treaty wording to locate the northeast termination point of the reserve, why does he mark it in a different location? Could it be he was influenced by some other instructions? Perhaps the Cway Road Amendment? How could he ignore midpoint Lot 31 as the northeast termination point when he has physically visited and recorded this location, not once, but twice? How could midpoint Lot 31 have been overlooked, yet again, a third time, by the Crown, when they were checking Rankin's work for errors? And, if this is not enough, how could the Saugeen Band of 1855, after just having the Crown correctly position the western boundary to Cway Road, accept an incorrect position of the northeast termination point at Lot 2526? According to SFN and Canada of today, the incorrect positioning of the Saugeen Reserve northeast termination point went unnoticed at least 4 times. Twice by Rankin himself, once by Canada's surveying experts, and one more time by the Saugeen Band, who were obviously keeping a close eye on the accuracy of the survey. Honestly, does this sound believable? 4. If Rankin's 1855 draft map is the most important map to verify the proper northeast termination point of the Saugeen Reserve, why is the western boundary omitted on the map? How can this map be used to establish anything, if it is incomplete? According to, not only the original treaty instructions, but also, the amended treaty instructions. The western boundary is the starting point for the 9.5-mile measurement. You need it to determine the northeast termination point of the Saugeen Reserve. The west boundary is not even included on the draft map, yet, according to SFN and Canada, this is the most relevant map to draw conclusions about the intended boundaries of the Saugeen Reserve. 5. How can the eastern boundary continue northward, from Lot 2526, to midpoint Lot 31, when Rankin's draft map clearly shows that this distance would run through the water of Lake Huron? 6. Why is the 1855 draft map marked at midpoint Lot 31 with a simple notation, Northeast Angle Indian Reserve, but on the Ridout and Schreiber survey, Rankin's post, is marked with an extravagant notation, Northeast Angle of Saugeen Indian Reserve, according to treaty boundary, heading south? These notations do not convey the same message, as you would expect. One is precise and definite, while the other leaves some doubt, with the added note, according to treaty boundary. Rankin noted a similar message in his diary, on September 1, 1855, as to what was found on the post, noted on the Ridout and Schreiber map, that he is going to survey the eastern boundary of the Saugeen Reserve, in accordance with the treaty. What was the point of making this confirmation, in accordance with the treaty, if the original treaty instructions were his only available choice? You would expect him to simply comment that he is going to survey the eastern boundary, period. A few days after this diary entry, he starts the survey of the eastern boundary at midpoint Lot 31, yet, he doesn't terminate the northeast corner of the Saugeen Reserve at midpoint Lot 31, he marks the termination point at Lot 2526. This is only 4 days, after he made the entry in his diary, that he was going to survey the eastern boundary, in accordance with the treaty. The only way to make sense of his diary entry, is to understand, that Rankin is using the method from the original treaty instructions, to survey the eastern boundary, rather than traversing the shoreline, for 9.5 miles, from Cway Road. It is the only sensible explanation, that answers why Rankin marked the northeast termination point of the Saugeen Reserve, at Lot 2526. The notation on the Ridout and Schreiber map, is remarkably similar to notations Rankin made, on another illustrated sketch. He made the notations, when he was discussing changes to the Saugeen Reserve boundaries, with Chief Alexander. In the sketch, Rankin identified the original western boundary with a note, by treaty. He marked Cway Road as desired by Alexander. Rankin also put notations of proposed changes to the eastern boundary. The change Chief Alexander wanted made to the eastern boundary was marked desired by Alexander, and the actual eastern boundary was marked boundary according to the treaty. Rankin used by treaty and according to treaty interchangeably throughout the sketch. On the note found at midpoint Lot 31, on the Ridout and Schreiber map, it is written, according to treaty, the same wording Rankin used on the sketch. SFN and Canada have used the Ridout and Schreiber notation as evidence that there are two separate maps, Rankin's draft map, and the Ridout and Schreiber map, that mark midpoint Lot 31, as the northeast termination point of the Saugeen Reserve. As I said before, the two notations don't match, they say two different things. The reality is, the Ridout and Schreiber notation matches Rankin's notations on his sketch map. It shows Rankin's method in describing proposed changes to boundaries. We know that the west boundary marked by treaty on the sketch was relocated to Cway Road. The according to treaty notation at midpoint Lot 31 is basically saying the same thing, that there is another consideration as to where the northeast terminus will be located. By following the amended treaty instructions, we know that location is Lot 2526. The similarity of these notations cannot be a coincidence, considering the directive of the Cway Road Amendment. What Rankin's sketch also shows is this: if there were going to be changes made to any of the reserve boundaries, concessions would have to be made by Saugeen First Nation. If the change to the eastern boundary, from this sketch, had been accepted, the northeast termination point of the reserve would have been significantly south of Lot 2526. When compared to Rankin's draft map, it appears that the northeast angle, illustrated on Rankin's sketch, would terminate approximately at what we know today as 16th Street South. This location is noted on the sketch as what SFN desired, in exchange for increasing the southern boundary to a width of 6 miles. Obviously, this is just a visual comparison, but from my experience, Rankin's maps are remarkably accurate. Although there is no scale, and the lots are not shown on Rankin's sketch, it is obvious, by comparing it to Rankin's other maps, that he has terminated the northeast corner of the reserve, at lot 2526 on the map, and has made note of it as, according to treaty. This is a further indication that Rankin has not considered midpoint lot 31, the northeast terminus of the Saugeen Reserve, since his initial traverse of the shoreline, in October 1854. Canada has stated that any other interpretation of the events surrounding the treaty, other than their own, would defy logic. Nonetheless, these 6 questions create glaring inconsistencies for the argument SFN and Canada are presenting. It shows that it is their interpretation of the events surrounding the treaty that defies logic. The entire basis for their argument is built on supposition, conjecture, and assumption. The only thing that can be verified through their argument, in reference to the Saugeen Reserve boundaries, is that the distance from the original western boundary to midpoint lot 31 equals 9.5 miles. Considering it is also 9.5 miles from Cway Road to lot 2526 Main Street, that is not much of an argument to go on. The fact that these two measurements both equal 9.5 miles illustrates the importance of interpreting Lord Barry's instruction to Rankin correctly. He instructed Rankin to carry out the survey of the Cway plot in strict accordance with the terms of the treaty surrender. When this statement is interpreted correctly, everything begins to make sense. It is obvious the directive of the Cway Road Amendment is to alter the original wording of the treaty. By doing so, it creates a domino effect in the ability to answer questions regarding the events surrounding the treaty. Questions that seem to have no answer. By completing this simple alteration to the text, as instructed by the amendment, it gives you an exact match to Charles Rankin's final and official map of 1856. How exactly does this defy logic? By this analysis, the Cway Road Amendment cannot be a stand-alone agreement. SFN and Canada insist the Cway Road Amendment is a stand-alone agreement. An agreement separate, and in no way connected, to the original Treaty 72 instructions. It is vital to their argument that the amendment is a stand-alone agreement. They believe the proof comes from the amendment itself, when it states that the amendment would give the Saugeen Band a small increase in frontage on Lake Huron. They believe this to mean the shoreline itself increases beyond the mutually agreed upon treaty term of 9.5 miles. They believe the increase mentioned in the amendment is describing the distance along the shoreline from Cway Road, where it is bound to Lake Huron, to the northern point of the original western boundary. Therefore, the amendment would have to be a stand-alone agreement for their argument to be correct. Since SFN and Canada have already used the 9.5 mile distance separately, by insisting the original treaty wording is to be followed, they are saying the treaty term of a 9.5 mile shoreline has nothing to do with the directive of the Cway Road Amendment. So, is the 9.5 mile shoreline boundary a treaty term, or isn't it? If it is not a treaty term, how else could it be described, without using a word that is synonymous with the word term? Lord Barry said, to survey the Cway plot, in strict accordance with the terms of the surrender. It is evident, a 9.5 mile shoreline boundary was observed, both in the original treaty instructions, and again, when the treaty was amended. It would be hard to argue that a 9.5 mile shoreline boundary is not a term of the surrender. A term that Lord Barry ordered to be recognized when surveying the Cway plot of land. Having matched the amended treaty terms to Rankin's final map, I have illustrated that the amended treaty wording was used to define the outline of the Saugeen Reserve. So, if the Cway Road Amendment cannot be a standalone agreement, how can there be an increase in frontage on Lake Huron? This was my next greatest stumbling block. Even after matching the treaty terms to the final map, I knew that the increase in frontage statement from the amendment still left a small ambiguity in the evidence. The court rules in favor of First Nations when there are ambiguities, so I felt that I had to remove all ambiguities from the equation. The key question to this part of the investigation is, why did the amendment refer to the frontage on Lake Huron only as an increase and not identify the actual distance? I can't stress the importance of this question enough. A question SFN and Canada didn't care to resolve, or even felt they needed to. I had 3 separate possibilities to explain the increase in frontage, but I couldn't come up with conclusive enough evidence, based on my own understanding, to support them. Not until the trial, when expert testimony revealed that the increase in frontage, stated in the amendment, was describing the area of land from the original western boundary out to the shoreline of Lake Huron. This statement supports one of the possibilities from my research, that is the most logical explanation for the increase in frontage. It was also revealed at trial that the increase in frontage was also describing the shoreline itself. It is possible the increase in frontage was describing 2 definitions of frontage. However, without an identified shoreline distance, it is highly unlikely. And it is only possible if the increase is in addition to the 8.1-mile shoreline Rankin was planning before the amendment. Why is this the only possible way for 2 definitions of frontage to be used? Because the distance from point A, Cway Road, to point B, the northern termination point of the original western boundary, is to be surveyed as part of the treaty term of a 9.5-mile shoreline distance. Lord Barry ordered the Cway plot to be surveyed in strict accordance with the terms of the surrender. If the point A to point B distance is not included in the 9.5-mile measurement, the shoreline boundary would be 11 miles, not 9.5, as required. Whether you base your interpretation on the amendment describing 2 definitions of frontage, or 1 definition of frontage, the reserve shoreline still has to equal 9.5 miles to satisfy the treaty terms.
Definition of frontage. 1. A piece of land that lies adjacent, as to a street, or the ocean. 2. The land between the front of a building and the street. 3. The length of a frontage.
Based on all available evidence, the definition of frontage that matches the reference to frontage made in the amendment is definition 1, a piece of land that lies adjacent to something. The increase in frontage on Lake Huron, described in the amendment, is referring to the piece of land that lies adjacent to Lake Huron, from the original western boundary out to the Lake Huron shoreline. Before the trial, I wasn't 100% sure if I was interpreting the first definition of frontage correctly, so I began thinking of other possibilities. I came up with one possibility that uses 2 definitions of frontage, the same as the expert, but obviously with a different conclusion. Without an identified distance of the shoreline, using 2 definitions of frontage doesn't make sense. The last possibility I produced, I had supported right up until the trial, and it is part of the last video I made. I have since dismissed this theory, because it cannot be proven, based on the evidence. Now that my initial analysis of frontage has been verified by an expert, that the increase in frontage matches definition 1, I consider my first answer to be the most accurate, logical, and conclusive, compared to any other explanation, including the experts. While researching this problem, I examined the entire memorandum that contained the Cway Road Amendment, and noted that the Cape Croker Amendment was also contained within the same memorandum. When describing shoreline frontages in the Cape Croker Amendment, it identifies increases and decreases in frontage in terms of a recorded distance in miles. This raises a very significant question. Since they identified frontage increases in terms of distance at Cape Croker, why was the distance of increase to the shoreline, from point A to point B, not identified at Cway Road, the same way as it was identified at Cape Croker? The answer to this problem, once again, comes back to Lord Barry's statement, as ordered by the Governor-General. The answer is then reinforced again by a statement made by Saugeen First Nation themselves, when they complained to Charles Rankin of the western boundary location, in May 1855. When Lord Barry states that the amendment is to be carried out in strict accordance with the terms of the surrender, he is saying that the treaty term of a 9.5-mile shoreline is to remain 9.5 miles, to agree with the original treaty agreement. The shoreline frontage, in terms of distance, from point A to point B, does not increase. It is already accounted for in the treaty term of 9.5 miles, and deserves no further consideration. Cway Road is the starting point, and 9.5 miles from that location is the northeast termination point of the reserve, at Lot 2526 Main Street. The only increase comes from the area of frontage on Lake Huron, from the original western boundary, out to where it meets the shoreline. This explains why no distance was mentioned in the amendment. It is visually apparent what the increase is, and, since there is not an increase to the shoreline itself, there is no need to record a distance. The mention from the amendment of a small increase in frontage on Lake Huron is not ambiguous when interpreted correctly. What also needs to be considered is, what would be Lord Barry's reason for making the statement to Rankin in the first place? Why would Lord Barry feel the need to instruct Rankin to survey the Cway plot in strict accordance with the terms of the surrender, if the amendment was a standalone agreement? If it was a standalone agreement, as SFN and Canada say, the treaty terms would have no effect on how the Cway plot was surveyed. The Cway agreement would have been a new and separate project for Rankin. A project that would have required a new set of instructions, and would in no way be influenced by the original treaty instructions. Alternatively, the only reason Lord Barry would have to give the instruction to Rankin is to make sure he understands that the treaty terms are to be recognized, meaning the Saugeen Reserve shoreline boundary is to remain 9.5 miles in distance. Using this reasoning, it is quite logical for the treaty terms to be consulted. Rankin marked the northeast corner of the reserve, at Lot 2526, which is 9.5 miles from Cway Road, when measured along the shoreline. A treaty term that is to be recognized and adhered to, as Lord Barry ordered. It is obvious Rankin heeded Lord Barry's instruction. It explains why the northeast termination point of the Saugeen Reserve is at Lot 2526, even though it doesn't agree with the original treaty text. There were no mistakes made after the Cway Amendment was put in place, including the survey of the Saugeen Reserve's eastern boundary. There is also no mystery why the northeast termination point of the Saugeen Reserve is located at Lot 2526. Terminating the reserve at Lot 2526 was a simple correction to a misunderstanding regarding the geographical direction of Cway Road during the initial negotiation stage. Charles Rankin's report to Lord Barry is further corroboration that the Cway Road Amendment is not a standalone agreement. Rankin reported to Lord Barry that not only could the amendment be done in strict accordance with the treaty terms, as Barry had instructed, but it could also be done without having to surrender the amended territory back to Saugeen First Nation. When Rankin made this statement to Lord Barry, it had been several months since he had completed the Grey Bruce map. On the map, He marked Lot 2526 as the Saugeen Reserve's termination point. The original western boundary is also clearly identified. Therefore, when Rankin made the statement to Lord Barry, he did not believe it was possible for the shoreline boundary to be 9.5 miles in length, using the original treaty instructions. This is the only possible explanation that allows Rankin to confidently give Lord Barry assurance that the Cway plot could be surveyed, without surrendering it back to Saugeen First Nation, or altering the treaty terms in any way. It has been suggested, by one expert, that Rankin only meant this to be temporary. But Lord Barry made it official and permanent through the Cway Road Amendment. Guided by Rankin's recommendation, Barry requested the change to the shoreline boundary to the Governor-General. It was approved in August 1855, without anything being surrendered back to Saugeen First Nation. This was achieved by surveying the Cway plot in strict accordance with the terms of the treaty surrender. Without following the terms of the treaty, as was instructed, the Cway plot would have needed to be surrendered back to SFN. No one has given any consideration to the significance of Rankin's statement when it is coupled with Lord Barry's instruction. How can the Cway Road Amendment be a standalone agreement, as SFN and Canada contend, if the Crown did not have to surrender the Cway plot back to Saugeen First Nation? According to the original wording of Treaty 72, the increase to the Saugeen Reserve that the Cway Road Amendment describes was considered surrendered territory from October 1854 until the Cway Road Amendment was agreed to in July 1855. For at least 9 months, the Crown considered the Cway plot to be Crown land and not part of the Saugeen Reserve. Once the treaty was signed, in October 1854, the Crown occupied and owned that portion of land. There is no mistake. According to the original wording of the treaty, it was the belief of the Crown that the outline that makes up the Cway plot of land had been surrendered to them by Saugeen First Nation. Saugeen First Nation, however, at the time of the treaty signing, were under the impression that the Cway plot of land was included in the original instructions as being part of their reserve. This being so, and to agree with SFN and Canada's argument, it would mean from the Crown's viewpoint in 1855, in order for the Cway plot of land to be given back to Saugeen First Nation, and at the same time, for the original treaty wording to remain intact, a new agreement would be needed to describe the Cway Road boundaries. But more significantly, the increase in frontage from Point A, Cway Road, to Point B, the northern limit of the original western boundary, would need to be identified in terms of a measurable distance. This is the only way the evidence can align with SFN and Canada's argument. As it stands in the Cway Road Amendment, the only boundary identifiers are Cway Road itself, and that there is an increase in frontage on Lake Huron. Without the understanding that the treaty terms are to be included, this description is too vague to describe the Cway plot of land. With the understanding the treaty terms are to be observed, no description of the Cway plot boundaries are needed. Rankin's reply to Lord Barry means this. Since Rankin is instructed to keep the shoreline boundary distance at the required treaty term of 9.5 miles, there is no need to write up a separate set of instructions, since nothing is being surrendered back to SFN. The treaty term of a 9.5-mile shoreline boundary and Cway Road are the only two boundary identifiers needed to connect the Cway plot of land with the rest of the Saugeen Reserve. The amendment is simply a modification to the original treaty instructions, and nothing more. The interpretation I have given matches Rankin's final map. The interpretation SFN and Canada have given doesn't. How is this an argument? In 1855, Saugeen First Nation described the increase in frontage from a slightly different perspective. When they made their complaint about the western boundary location, Charles Rankin took their complaint to Lord Barry and explained to him that SFN's understanding of the negotiations was this: that Cway Road was where the western boundary was to be bound to Lake Huron, and that they wanted everything to the north of it. This description, from Saugeen First Nation, verifies that Cway Road is the location they understood to be the starting point for the 9.5-mile measurement. This also verifies that there was no increase in frontage from point A to point B along the shoreline beyond the agreed-upon treaty term of 9.5 miles. In this description, SFN is describing everything north of Cway Road, out to the shore of Lake Huron, as the increase in frontage, rather than everything west of the original western boundary, out to the shore of Lake Huron. By September 1855, both Saugeen First Nation and the Crown, through the Cway Road Amendment, recognized this distance from Cway Road to the northern point of the original western boundary to be part of the 9.5-mile shoreline boundary. A correction to the original treaty instructions, in order to recognize the true treaty intentions of both negotiating parties. To summarize, using the theory from SFN and Canada's argument, if the Cway Road Amendment is a stand-alone agreement, the original treaty wording does not match any of Charles Rankin's maps. On the other hand, still using SFN and Canada's argument, if the amendment isn't a stand-alone agreement, and you try to incorporate the amendment's directive as part of the original treaty instructions, the shoreline boundary length becomes about 11 miles, which does not agree with the treaty term of 9.5 miles. In addition, in 1854, the eastern boundary, from Lot 2526 to midpoint Lot 31, could not be contained within a block of land. The SFN and Canada argument does not work either way. The Cway Road Amendment being a stand-alone agreement, or the amendment being part of the original treaty instructions. It is obvious they have made a mistake. They are using the wrong treaty instructions. How do SFN and Canada know the increase in frontage on Lake Huron includes a shoreline distance from point A to point B? They don't. Their explanation is based entirely on assumption. They simply assume an unidentified shoreline distance of 1.4 miles between Cway Road and the northern point of the original western boundary is what is meant by a small increase in frontage on Lake Huron. There is nothing stated in the amendment that verifies this belief. Nothing. Do they really think it is pure coincidence that it is the same distance along the disputed beach shoreline, from Lot 2526 to midpoint Lot 31, as it is from Cway Road to the northern point of the original western boundary? They don't acknowledge these things, they ignore them. The same way they don't acknowledge that the amended treaty instructions match Rankin's final map. How do I know that the increase in frontage is only from the western boundary, out to Lake Huron? Because the shoreline frontage, from point A to point B, has already been accounted for in the 9.5-mile measurement. Which brings me to the defining moment of proof, for how I know. The amended 9.5-mile measurement description, from Cway Road to Lot 2526, which includes the distance from Cway Road to the northern point of the western boundary, is a perfect match to the shoreline boundary of the Saugeen Reserve, illustrated on Rankin's final map. That is not an assumption made by me, that is a fact. SFN and Canada have been given a free pass. At trial, when it was finally revealed that the distance from Cway Road to Lot 2526 is 9.5 miles, neither SFN nor Canada were asked to explain this mysterious coincidence, compared to what they had presented at trial. The following is a summary of the 7 main pieces of evidence, from my research, that was not heard at trial. 7 more substantial pieces of evidence, neither SFN, nor Canada, has had to answer to. But what's worse, 7 pieces of evidence, Superior Court Justice of Ontario, Justice Vella, never heard. 1. Evidence confirms that Rankin knew, as early as January 1855, that he would be positioning the northeast corner of the Saugeen Reserve at Lot 2526. The scale of the Grey Bruce map confirms this. 2. The Ridout and Schreiber map shows a notation, at midpoint Lot 31, that there is a post marked as northeast angle of the Saugeen Reserve, according to treaty boundary, running south. There is no reason to record it this way, if there wasn't another consideration to be made. If there wasn't another consideration, it should have been simply recorded, Northeast Angle Indian Reserve, the same way it is recorded on the draft map. The note on the Ridout and Schreiber map directly relates instead to the way Rankin made notations on a sketch map when he was negotiating boundary changes with Chief Alexander. 3. At trial, it was never considered that the original treaty instructions were altered by the Cway Road Amendment. At trial, it has been accepted that the original treaty wording was used, without any consideration, for the Cway Road Amendment's directive. The Cway Road Amendment was not a standalone agreement. The word, instead, from the Cway Road Amendment's text confirms that the additional words from the amendment's directive were to be inserted and merged with the words of the original treaty text. 4.
There would be no harm by gratifying them, and allowing them the use of it, which of course can be done, without either re-surrendering it to them, or altering the terms of the treaty in any way.
Rankin's reporting statement to Lord Barry was given no consideration at trial, as to its actual meaning. The words of the treaty were definitely altered by the amendment. So, when Rankin says the amendment can be done without altering the terms of the treaty in any way, he is referring to the concepts of the treaty, not the actual words of the treaty. Since the amendment can also be done within the terms of the treaty, there is no need to surrender the Cway plot back to Saugeen First Nation. 5. The explanation of increase in frontage on Lake Huron that I have offered was not heard at trial. An actual distance along the shoreline, in terms of miles, or any other measurable distance, is not identified in the Cway Road Amendment. All parties at trial, including experts for the defense, assume it is referring to an increase in distance along the shoreline, as well as the area of increase from the western boundary out. The court has been misled into believing the original treaty instructions and the Cway Road Amendment have nothing to do with one another. This makes absolutely no sense. 6. There is a small portion of the original western boundary that still remains after the majority of the boundary was relocated to Cway Road. The 3 surveying experts at trial made no mention of this remaining portion, since they believe the original treaty wording was used, and this portion of the western boundary is included in that description. I maintain that the remaining portion of the western boundary is actually described by the amended treaty instructions, exactly the way it is shown on Rankin's final map. My explanation does not rely on the western boundary extending to the shore of Lake Huron. By merging the treaty instructions, as instructed through the amendment's directive, the remaining portion of the original western boundary is actually identified as connecting to Cway Road.
All that block of land, bounded on the west by the Indian path called the Cway Road, which takes a northwesterly direction to the shore of Lake Huron, from a straight line running due north from the river Saugeen.
7. As for the most important evidence from my research, It was never revealed at trial that the amended treaty instructions are an exact match to the illustrated boundaries of the Saugeen Reserve, found on Rankin's final map, Map 862, the plan that was officially registered by the Crown in 1856. Unbelievably, no one thought that this was significant enough information for Justice Vela to hear. It is incomprehensible that something this significant would not be acknowledged. This presentation has been a comparison of my research to that of Saugeen First Nation and Canada. Many will say, because I am a named defendant, that I am biased, that my analysis can't be trusted. Nonsense. What I have presented are not theories. I have backed up my conclusions with facts. I have disputed SFN and Canada's conclusions with facts. My conclusions have matched the treaty terms to Charles Rankin's final map, and that is a fact. Their conclusions haven't. That is also a fact. There is no bias in facts.